specialize in domestic violence prosecution as well as sexual assault prosecution. So it is a bit of a grim line of work. However, I love what I do. I love working with people from all different backgrounds, all different educational backgrounds, career backgrounds, and it's a very rewarding career overall. So if there is anyone here who's interested in the law, or especially as it pertains to criminal law in these particular areas, please reach out. I would love to talk to you about it. So the role of the prosecutor, for those who don't know, what happens first is that the police department usually takes control of an investigation. So they'll go through and they'll investigate and they'll make a certain determination of what to do. I'll go into that a little bit later. And when the police end their involvement, the prosecutor's office usually takes the baton and we go from there. So what I do as a prosecutor is I get a case and I analyze the case and determine first if I can pursue criminal charges. So I have to have probable cause to do that. I have to also believe there is a reasonable likelihood of conviction. And there are a lot of ethical considerations to take there as well. And so then if I decide to move forward with charging, I will file the documents and then it goes through the court system. And again, I'll go into that in more detail a little bit later, but normally what happens is, we get a defense attorney involved and the two parties see if we can come up with some kind of resolution. If we cannot do that, then the case typically goes to trial and then I represent the state at trial. So I'm the one in the courtroom taking the case to trial, presenting evidence, and then getting either a judge or jury to convict the offender, and I have to prove the case beyond a reasonable doubt. So how I get a case. There are two primary ways a case comes to my office. The first way is that police will actually make an arrest. So if some kind of crime has happened, they can make an arrest at the scene. The benefits to that are if there is a public safety issue, or if this person is a very real, immediate danger to the life and safety of others, police will make an arrest, and then the case gets sent to our office. The downside to that is that kind of starts the clock ticking immediately. We have to start filing things immediately. We have to be ready to go to trial at a moment's notice. And so for cases involving sexual violence, that's not always what happens because they are very complicated cases. They are known to be some of the most difficult cases to prosecute. So for that, we are usually working with law enforcement, and law enforcement is going into a very thorough investigation, looking through medical records, talking to potential witnesses, talking to potential friends of the survivor, or talking to the survivor herself, and trying to get as much information as possible. So in that second way, when they're not doing a custodial arrest, what they'll do is they'll collect all the information possible, and then they will send the case to our office. And I'll receive a file, and I will go through the file, and that's when I start my analysis. So again, the benefit to that is I can make sure that all of the T's are crossed and all of the I's are dotted before I move forward with the case. The downside to that is that obviously if this person, this perpetrator, is still out in the community, that is obviously very impactful for a survivor, that they have to maybe still be in the same community as the perpetrator, and that person doesn't really know where that file is in my office or how close it is to being charged, and that can be very emotionally draining and very impactful for a survivor. So there are pros and cons to both sides, but that is ultimately how a case ends up in my office. So I also want to talk about Indiana law as it pertains to sexual violence. Indiana is very good about certain parts of this type of crime, but there's also a lot to be desired. However, we do have several statutes that we look at when it comes to sexual violence and the law. So the first crime is rape, and what we have up here is we have all of these elements. So the state, if we were to take a rape case to trial, we need to prove all of these beyond a reasonable doubt, and there are different subsections. So we first have to prove that there is the person, so that we have the right individual in court, knowingly or intentionally that they knew what they were doing, and that has sexual intercourse with another person or causes another person to submit to other sexual conduct when, and then we have these four options up here. So the first one is the other person is compelled by force or the imminent threat of force, that the other person is unaware that the sexual intercourse or other sexual conduct is occurring. 3, the person is so mentally disabled or deficient that consent cannot be given. And 4, the person disregarded the other person's attempts to physically, verbally, or by other visible conduct refuse the person's acts. Yes?
Are those separated by or an
Or. So we don't have to have all of these present in order for us to charge rape. just one of these four? It's a really good question. And it was not too long ago where Indiana only had the first three. So we didn't have this, and the number four is pretty much, when the victim says no, and the perpetrator ignores that request or ignores that no. And so Indiana did not have number four for a very long time, and that was only just added, I want to say, a year or two ago. So we were in a really rough spot where we would have a case because a lot of times a survivor will report, a fight, or what's most common is freeze. And so if something is happening and that survivor just freezes and doesn't necessarily fight back, there's not force, they had their wits about them, it wasn't falling into any of these categories. So we had a lot of situations where, you ask any person on the street, it would be considered rape, but we couldn't charge it. And that was very, very difficult, and it was a very hard conversation I had to have with a lot of people. Fortunately, the state got with the times. We have number four now, so even if the survivor says no, and that perpetrator continues to disregard that, we can still charge rape. And I think we've seen a lot of good from that. So that was certainly a beneficial thing that's happened over the past few years. So the other charge is sexual battery. And this is kind of a weird statute. It's a bit of a weird crime. So we have a person with the intent to arouse or satisfy that person's own sexual desires or the sexual desires of another person. So the first option is touches another person when that person is compelled to submit to the touching by force or imminent threat of force, or so mentally disabled or deficient that consent to the touching can't be given. Also touches another person's genitals, pubic area, buttocks, or female breast when that person is unaware that the touching is occurring. So sexual battery isn't necessarily intercourse or it's not other sexual conduct, but we see this in groping quite a bit. It's a level 6 felony, so it's not as high of a felony as rape. And as you can see here, we also don't have that, the person says no, the perpetrator keeps going. So we don't have that element here with sexual battery. This is a very, like I said, it's kind of an odd statute. It's very hard to explain to juries. It's very hard to explain to just anyone. It's also hard to charge, it's hard to prove. But we still do. And I know that I can think of a couple of instances, it just doesn't cover everything. So I know we had a case once where a person she was asleep and someone actually ejaculated on her while she was still sleeping, and it didn't fit any of these crimes. We didn't know what to charge for a long time because there was no actual touching, there was no force, and it wasn't rape because it wasn't sexual intercourse or other sexual conduct. So we ended up having to charge battery as a B misdemeanor. And I know other people have run into that situation as well in other counties. So it is something that we are trying to work on down in Indianapolis. But as of now, this is where the law stands. And we've certainly had some issues with it because it can be really complicated. So these crimes are enhanced to a higher level felony, meaning there is more potential exposure for prison time. The sanctions are much harsher. If it is committed by using or threatening the use of deadly force, or committed while armed with a deadly weapon, or if it results in serious bodily injury to a person other than the defendant, or if the offense is facilitated by furnishing the victim without the victim's knowledge with a drug. So that, if we have any of these particular situations, that will enhance the crimes to something a lot more higher, a lot more serious. So we've seen in the other slides that we have rape and we have this just goes to rape. We have other sexual conduct, and this is how it's defined under Indiana law. So it's an act involving the sex organ of one person and the mouth or anus of another person, and the penetration of the sex organ or anus of a person by an object. So that is how we define other sexual conduct here in Indiana. Now, serious bodily injury, that's what makes a crime more serious. For example, for rape, it'll take it from a level 3 felony to a level 1 felony, so a much more serious penalty. Serious bodily injury is bodily injury that creates a substantial risk of death or causes serious permanent disfigurement, unconsciousness, extreme pain, permanent or protracted loss or impairment of the function of a bodily member or organ, or loss of a fetus. So any of these makes it a much higher level crime. So I put up domestic battery because unfortunately domestic violence, intimate partner violence, and sexual violence tend to go hand in hand. So I put this up there because it's something that we frequently see with sexual violence cases as well. In fact, we'll usually charge a case and it'll have several counts, some being a sexual violence count and others being a domestic battery charge. So for domestic battery, to prove this beyond a reasonable doubt, we need to prove that a person, knowingly or intentionally, touches in a rude, insolent, or angry manner Another person who is a family or household member. So if you touch a family or household member in a rude, insolent, or angry manner, that is the crime of domestic battery. And I throw this up there because I have to look up what insolent means every single time I talk about this, and it's ultimately a lack of respect or just being rude. So family or household member, this was something that was changed, I want to say about 7 or 8 years ago. So prior to this, the law really just applied to if you're married or dating. But then the law changed to really expand on what a family or household member is, and that was certainly another very beneficial change to the law. So it's a current or former spouse, if you're dating or has dated, if he is or was engaged in a sexual relationship, related by blood or adoption, is or was related to marriage, previously established legal relationship, like a guardian, a ward, custodian, a foster parent, or if you have a child in common with the other person. So this makes it so that even if you are not currently in an active dating relationship with that person, but you have been in the past, and that person touches you in a rude, insolent, or angry manner, it is still constituted as domestic battery. And again, these are enhanced for if you have serious bodily injury, if there's a deadly weapon, if the victim is pregnant and the perpetrator knew of the pregnancy. There's a lot of ways to make this a much higher level felony. Now, strangulation is also something that we talk about a lot. It's something that we tell law enforcement to please encourage them to go to the St. Joseph Regional Medical Center for a strangulation examination. We are seeing strangulation in a lot of sexual violence cases. We're seeing a lot of domestic violence cases, and it is so incredibly serious. And I think now we are trying to get more training for law enforcement so that they truly understand just how serious strangulation is. I'm not a medical expert, so I can't really go into all of the ins and outs, but ultimately we're seeing strangulation cases where something happens and then the person doesn't experience the serious effects of strangulation for months or sometimes even years. So we are now encouraging law enforcement that if there is any sign of strangulation, especially in a sexual violence case or intimate partner violence case, that they go to a hospital to get a scan almost immediately, because there are just so many blood vessels, there are so many airways. It's such a problematic offense, and it's just very, very damaging to a person's health. So strangulation, fortunately, I think people are starting to understand more and more just how serious it is, but it's definitely something that we need something to work on. So strangulation, to define it, and this is what I would have to prove if I were to take this case to trial, is a person in a rude, insolent, or angry manner, knowingly or intentionally, either applies pressure to the throat or neck, obstructs the nose or mouth, or applies pressure to a person's torso. So we've seen that before, where maybe a perpetrator will sit on someone's chest and impede the normal breathing or blood circulation to another person. So it doesn't have to completely cut off the airway, as long as it's just affecting the breathing. That still constitutes strangulation. For example, we have survivors of strangulation all the time who will be asked, could you still breathe? And they say yes, and so maybe a police officer just moves on and doesn't think this is strangulation. But in reality, it was more difficult for them to breathe. Their airway was still affected, the blood flow was still affected. So in a perfect world, that person would be seen to make sure that they are medically okay by a forensic nurse with this kind of background. So then we have stalking as well. And again, these aren't explicitly sexual violence cases, but they seem to go hand in hand quite often, especially when we're getting to sexual violence, intimate partner violence. And stalking is another crime along with strangulation that I think, fortunately, we're getting more training, and most people understand how lethal stalking is. We have retired Detective Justin Boardman, who was quoted as saying stalking is homicide in slow motion. And I think that's perfectly accurate. More and more research is coming out, more studies have come out to suggest that someone who is willing to engage in some kind of stalking behavior is more likely to commit some kind of act of lethality against an intimate partner. So stalking is defined under Indiana law as a knowing or intentional course of conduct involving repeated or continued harassment of another person that would cause a reasonable person to feel terrorized, frightened, intimidated, or threatened, and actually causes the victim to feel that way. So we ask law enforcement typically to look for a pattern of escalating behavior. So it may start with a text or two asking about the kids or asking about how your day is. And then when that affection is unrequited, it usually ups the ante and people get more and more alarming with their behavior. So one of the reason stalking wasn't always taken very seriously was because some of the behavior seemed really innocuous. We have some cases, for example, where a person was just leaving flowers on someone's car windshield. And on its face, someone might say like, oh, he's just being nice, he's trying to get your attention, he's trying to show some kind of sign of affection. When in reality, if you look from the victim's point of view, who maybe has been in an intimate partner violence relationship or has been subjected to sexual violence, that's actually very scary because they know that the perpetrator is saying, I know where you work, I know where your car is, I can come find you. So that stalking is, even though it might seem, again, maybe harmless on its face, can actually be pointing to something extremely dangerous. So we look for maybe driving by, following and monitoring the victim. We're seeing more and more GPS tracking devices, which fortunately the legislature saw that as well, and that means it can be upped a little to a higher level felony. Showing up where the victim is, repeated phone calls, voicemails, text messages. So all of that, if that is something that anyone is going through, I always encourage to keep as much evidence as you possibly can. Yes?
I've seen on two of your slides that it says knowing and intentional.
Yes.
Do you have defendants that could apply it? Or what constitutes like knowing? Intentional is very different. But
Sure. So the question was kind of talking about, we see knowing or intentional. And so under Indiana law, there's different levels of culpability. It's also called mens rea, if you're criminal justice majors or anything of that. So knowing doesn't necessarily mean whether or not the law exists. Like, I didn't know that was a law. That doesn't count. So ignorance of the law is no excuse. That's a pretty common phrase, and that's what that means. So knowing modifies the behavior. So you knew what you were doing. So a lot of times we will say that we will find that people say, oh, I didn't know what I was doing was stalking. But they did know that they were engaging in this kind of behavior and it would cause that person to feel threatened. So the example I give when I'm trying to explain what this is, the difference between knowing and intentional, it's like if I'm standing in this room and I have a tennis ball, and if I tell someone I'm gonna chuck this tennis ball out that window and break it, and I do, obviously you have enough evidence to show that I intentionally broke that window. But maybe if I'm just kind of bouncing the tennis ball around and then I just throw it in the general direction of the window, it hits the window, it breaks the window, I still acted knowingly because I knew what I was doing, ultimately. I understood that the reasonable likelihood that my actions would cause that window to break. So that's kind of how we explain it. It's a legal term of art. It can get a little confusing at times, but ultimately, if you are swinging your hands wildly and you make contact with someone who's nearby, you are acting knowingly. You knowingly battered that person because you understood that by waving your hands around wildly with someone right next to you, that there was a plausibility that you could hit that person. So that's how I explain it. Does that make sense? Okay, like I said, it's a legal term of art, it's a little tricky, but ultimately how I explain it is, you know what you're doing at the end of the day. Okay, so sexual assault first response, going into this a little bit. If you are a support person or you yourself have been victimized by some kind of sexual assault, we ask that you first address any needs for emergency medical attention. We usually talk about the St. Joseph Regional Medical Center. They have one of the best, if not the best, forensic nursing department in the area. We always encourage people to go to St. Joe because they do have just a top-notch team. So we also encourage the survivor to avoid showering, bathing, going to the bathroom, drinking, brushing their teeth, changing clothes, etc., because that could potentially contaminate any evidence that might be needed later on. So we'll talk about this a little bit. That doesn't happen in every situation, and we completely understand, because when a survivor goes through a significantly traumatic experience, everyone's going to react differently. Everyone is going to want it handled a different way. But these are just general guidelines that especially we get to law enforcement if they get some kind of report. So even if the survivor doesn't want to file a report to law enforcement, the sexual assault exam can still be completed just in case they change their mind. You do a Jane Doe kit, there's no cost. And what we tell law enforcement, what I encourage other people as well, is secure the scene. And this sounds very depersonalized, but as law enforcement is typically trained, there are at least 3 crime scenes in some kind of sexual violence case. So we first have the location, and then we have the survivor, and then we have the suspect, because both of them will usually have biological evidence that can disappear pretty quickly if it's not addressed quickly. Again, that doesn't mean it's not fatal to the it's fatal to the case. So I've had some survivors who delay reporting for days, weeks, months, or even years. And we can still prosecute the case, but this is just best practice, again, especially when I give this training to law enforcement who are learning how to respond to these very, very sensitive situations. And we also encourage people to contact law enforcement for 911. So these are victim rights prior to some kind of sexual assault examination. These are pretty new, and there's usually a handout that each hospital gives. So you have the right to speak with a victim advocate or victim service provider during any hospital visit. So you have the right to be treated with fairness, dignity, and respect, free from intimidation, harassment, and abuse throughout the criminal justice process, actually in our Indiana Constitution. Your private communications with a victim advocate, victim service provider, victim's assistants, or a social worker are not admissible into evidence for any purpose except with your consent. So usually a hospital has some kind of social worker program or a victim advocate available, and that's when it can be confidential. Each prosecutor's office also has a victim's advocate, particularly for these crimes, but that is not necessarily confidential because they are working for a prosecutor's office. Or I know a lot of police departments are starting to employ more social workers. That also gets a little dicey because that person is an employee of a police department, not necessarily a hospital, so confidentiality gets a lot more gray in those particular areas. So you have the right to speak with a victim advocate or victim service provider during the course of the investigation, and you have the right to be provided with medical forensic exam and additional forensic services without charge. All right, so going back into kind of what I do and case analysis. Unfortunately, I cannot charge every case that comes across my desk, and that can be very, very difficult sometimes. There have been a variety of cases where I believe the survivor 100%, but I know ethically I cannot move forward with prosecution, and that becomes very, very challenging. These cases, as I mentioned before, are known to be one of the most challenging cases to prosecute anyways. So if I get a case, I kind of have to think about what happens next. So something I usually make clear, and this happens in intimate partner violence cases as well as sexual violence cases, is that the survivor is not the one pressing charges in a criminal case. So a criminal case is different from a civil case. A civil case is when one party is suing another party for usually monetary reasons. In a criminal case, the state of Indiana is the one filing charges. So we certainly take the survivor's perspective into account, but it's not necessarily the deciding factor of whether or not a case goes forward. We have that for a variety of reasons. So ultimately, the state, looking at kind of the benefit to the community as a whole, we certainly don't want this to happen again. We don't want the perpetrator being able to go out and do this again to either the same survivor or to a completely different person. So we certainly have a stake in that. We also, generally speaking, don't want to live in a community where someone can commit an act of sexual violence on another person and get away scot-free. That's certainly important to us as a society, that we want people to be held accountable for their actions. Especially if we're talking about maybe domestic violence, we start thinking about the cycle of violence, and that we don't want the perpetrator to learn how to avoid accountability. So we don't want someone to say, oh, I can just kind of bully the survivor into recanting or going into the prosecutor's office and saying I want to drop the charges, and then I get away, because then that person just has a lot of positive reinforcement for very negative behavior. So if that happens, I would say, I don't even want to put a number on it, but most of our domestic violence cases, the survivor will come in and ask to drop charges for a variety of very understandable reasons. But as in Elkhart County, that's kind of our policy, is that we're still going to move forward if we have the evidence, because we definitely want to hold this person accountable, and we want to stop any kind of cycle. We want to stop this behavior. Looking at challenges in sexual assault prosecution, it's challenging for a variety of reasons. Something I have noticed just anecdotally is that when I take a case to trial, juries tend to be just automatically skeptical of adult survivors. Immediately they're thinking, well, what actually happened here? Or I frequently hear people say there's usually 3 sides to every story. There's the defendant, the victim, and then probably the truth is somewhere in the middle. So a lot of people say that. I've just noticed there tends to be more skepticism when it comes to believing survivors. That's something that I think is changing, and I've seen a lot of positive trends. I've seen a lot of education in the community to change that, but it's still something that we deal with pretty frequently. And then when we're talking about sexual violence, we're usually talking about a crime that occurred between two people in usually a place where there's no eyewitnesses, there's no cameras, there's not a lot of actual physical, tangible evidence to always present to a jury. So it becomes very, very challenging. Some of the most frequent challenges that I see in this kind of prosecution is that there's sometimes identification issues. So we have to make sure that the perpetrator is the right person. Typically, I don't see this as often just because, as I think we all know, sexual violence is usually committed by someone who's known to the survivor. We also have consent issue cases, and I think that's probably one of the most common, if not the most common, I see, is that we get to court, the defendant says, no, it was consensual. And again, that's something that I think juries are typically very skeptical of. It's something that we frequently have to overcome. Fortunately, as we continue to educate law enforcement, as we continue to educate ourselves and see what we can bring to trial, what actually convinces a jury to believe the survivor, we're able to overcome it, but it does become incredibly tricky. And then we have imperfect survivor cases. So we'll see, we'll have survivors come testify, and maybe they're not the most likable person, or maybe they engage in some behavior that some juries might see as kind of less than. Or maybe they have substance abuse issues or mental health issues. There's a variety of reasons that we have these so-called imperfect survivor cases. However, obviously we are, again, trending in a positive direction. I think most people understand that no matter who you are, none of us are perfect. We all have our issues, and that doesn't mean a person gets to be victimized. So fortunately, we've seen a lot of positive trends in that area. But one of the other reasons that we call them imperfect survivors is that some people don't react the way everyone expects them to, or they don't talk about it the way everyone expects them to, or they'll be on body camera and they're maybe giggling or swearing, or maybe really, really having a contentious interaction with law enforcement. So if you are someone who's not very well versed in sexual assault and reactions of a survivor, that can be very off-putting. So that's something that I know we're trying very hard to do, is to educate in this area that people react differently. So for example, this is so simplified, but we have the lizard brain, the prefrontal cortex, and then the lizard brain, kind of the amygdala. What's noted is that the trauma survivor often will be able to answer who, what, when, where, why, and how, because that requires the brain to engage in the prefrontal cortex, which was overloaded at the time of the trauma. Therefore, we can't treat trauma survivors as witnesses to their own trauma. Rather, they experience the trauma, so we should ask sensory, emotional, and experiential questions. And that's from Age, the police department detective, which couldn't be more astute. When someone has been through something incredibly traumatic, their brain is not operating as it does on a day-to-day basis. So we can't always trust them to be perfect witnesses to their own crime. It sounds a little weird, but they're experiencing it. So we'll have cases before where a survivor can remember, the smell of certain soap because that's what the perpetrator used before each assault, or they can remember how the basement floor felt on their back. Those certain sensorial and emotional feelings are something that are very, very specific, and something that I know medical personnel and law enforcement are trained to ask and trained to look for. But again, everyone remembers the assault differently, everyone reacts differently, and that doesn't necessarily mean it didn't happen. It's just, again, kind of educating the community that everyone reacts differently. So this is something that we work on pretty frequently. In sexual assault or traumatic experiences, we have a lot of inconsistencies. So, for example, the survivor might tell law enforcement one thing, and then they'll come to court and say something different. And so it used to be that if you were on a jury, you would hear that inconsistency, and you would immediately think that the survivor's lying. And that would be your first reaction, because everyone knows, it's hard to keep a lie straight, it's hard to keep the facts straight if you're lying, so we were met with a lot of skepticism. But that's not true, and we know that medically, because again, when your prefrontal cortex is functioning normally on a day-to-day basis, that can help us be rational, we can reason, we can have perception of control, we can have thoughts and behaviors that aren't based on reflexes or habits, and it focuses our attention. So now, if there's some kind of defense circuitry activated, it can happen during any kind assault, attacks, dangers, and that's different for everyone, how they perceive that and what kicks in that defense circuitry. So you're scanning the environment for threats, and it can vary from a split second and will take over. So trauma responses are normal biological responses to abnormal events. Survivors have a wide range of behaviors and may not feel appropriate for the situation. So again, some people, especially maybe a support person for a survivor, will start to question that survivor because they think, wait, she said this story now, and now she's saying something else. This can also be a result of trauma. Again, this cannot be any more simplified. I'm not a medical expert, but this is how it works. So we have the adrenaline, we have opioids, we have cortisol, all that just dumps into the brain, and it causes people to react counterintuitively, especially when there's some kind of assault. So you have this traumatic moment, you have this BAM moment, as some people refer to, where your prefrontal cortex is impaired, so your defense circuitry takes over, and it creates flashbulb or snapshot memories. So you might have a very vivid image at one point, and then it's fuzzy later. If you survive this event, your defense circuitry will try to overload that neural pathway so you can survive again, is ultimately what's happening. And from your BAM moment on, memories of that circumstance will get fuzzy because of the effect of trauma on memory. So a survivor may have a poor memory after the moment, especially when we're getting into sequence of events, what happened first, second, third, or beginning, middle, end. It can be very, very difficult for someone who has survived a traumatic event. And when we're talking to police, they'll try to ask what happened next, and then what happened next, which is not an effective way to actually get information out of a survivor because that order of events is going to be incredibly scrambled. So events and details outside of the perceived threat might be a little bit fuzzy, and the survivor may not remember the environment because she's so focused on the attacker's face or that particular snapshot or maybe the weapon. So we have maybe an expected object versus an unexpected object. Details just get very fuzzy. So as someone who prosecutes these types of crimes, it becomes, again, very difficult. I remember speaking to a victim once, and it was like pulling teeth. I couldn't get much information out at all, and I started to panic because I was thinking, I don't know how she's going to go on the stand, and she's not going to remember anything. Now, fortunately for that case, we had extensive medical records. We had some amazing medical professionals come in to testify to educate the jury about this experience. So we were in luck there, but that does create almost a panic moment for me, knowing that I have to present a case in court and I'm wondering, I have no idea what facts are going to come out during this trial. So these cases are also known to be very unpredictable. There might be a time where I speak to a survivor knowing that she's about to testify and she tells me the story and everything seems fine and consistent, and then going on a witness stand in a courtroom full of strangers is even more terrifying sometimes, and then the story completely changes. So we have to be able to work and to be very fluid with these types of cases. Again, what a survivor will remember is the details most important to survival, emotions, or sensations. So they might not remember what time this happened, or what hand was used to strike her face, or anything like that, because those are details that were just not necessary to survival. That survivor is not thinking, oh, I better remember every single detail perfectly because I'm going to testify a year from now. That's usually not what the survivor is thinking whatsoever. So something we also look to, because when we are dealing with maybe physical assault between two individuals and they're both claiming the other started it or they both claim the other was involved, we look to the difference between the perpetrator actions and the survivor actions, because sometimes it is counterintuitive. So a lot of times during an investigation, people will talk to the survivor of the offense and things are very jumbled, or he or she is frantic or having just a lot of problems getting that narrative out. And then they'll talk to the suspect, who is calm, cool, controlled, able to give a beginning, middle, end. So it used to be that investigators or people on a jury would think, oh, well, his story made sense and hers did not, so we're going to believe him. And again, that's where our education comes into play, that we expect someone who has survived an incredibly traumatic event to not be cool, calm, and collected, to have a lot of issues giving the narrative or remembering certain details or things come and go. Something that we typically see in these cases is that humans do have some kind of need to return to normal after trauma. Survivors are going to try to make everything feel normal after the fact, which then provides some hurdles in prosecution later. Again, we can still go forward. I certainly don't blame the survivor, but these are some of the, again, some of the challenges we have to overcome. So a survivor will clean up after the mess, not necessarily to hide evidence, but to just return to that normal state. So taking a shower after a rape, that is incredibly common. As a prosecutor, I think, oh my gosh, we just lost a lot of evidence, probably. But that's certainly not what the survivor is thinking. The survivor doesn't care about my case. The survivor cares about their safety, and they just want to get back to normal. We also see a lot where the survivor will delete all the text messages or the Snapchat messages or social media with the perpetrator because they just want to get rid of it and return to normal. So an investigator later says, oh, do you have the messages between you two? And then the survivor says, no, I deleted everything. If you're not well informed, that looks incredibly suspicious, when in fact it is perfectly normal behavior. Or if the survivor does speak to law enforcement, tries to mitigate the situation, I made them mad, everything's fine now, or no, we just got into a fight, it's okay, nothing happened, or they start to maybe self-blame or start to explain, well, I shouldn't have done this is my fault too. A lot of that is just to make this go away and just return to normal. A lot of times we will see that a survivor has feelings of guilt and embarrassment, and law enforcement or sometimes a support person can make this worse unintentionally. So there's a lot of why questions, and we're starting to work with police to stop asking why questions. Or if a person close to you comes and confides in you, questions of why tend to be a little bit more damaging. Mostly because when you start with the why, it's kind of, why did you do this? Why did you dress that way? Why did you go out? Why did you go back to his room with him? A lot of that, even if we're just trying to ask open-ended questions and really try to understand what the survivor has gone through, it just automatically puts them in defense mode, and they tend to be less cooperative with any kind of law enforcement or prosecutorial system down the way. I made a note here, but I see a lot where the survivor has a lot of guilt about the perpetrator as well. I hear a lot of times, I don't want to be the reason someone goes to jail, or I don't want to be the reason someone goes to prison. So that's one of the reasons that the survivor is not the one pressing charges, it's the state. We are trying to take that weight off of that survivor's shoulders and take it on ourselves. So that's what I usually tell them is, you did what you needed to do, I will take it from here. The consequences of what happens, that's not up to you. That's between the court, the state, and the defense attorney. So a survivor's perspective after an incident, typical, how am I supposed to heal from this? How do I return to normal? That's going to be what the written emphasis is. So if I report this to law enforcement, or if I cooperate, I might be taking away a child's father. There's a lot of financial issues as well. How will I pay the bills? I'm going to have to talk to a prosecutor. I'm going to have to talk to police. And then if this goes to court, I'm going to have to testify in front of strangers. What will my family think? What will my friends think? A big one is, I don't think anyone's going to believe me. I was intoxicated. No one's going to believe me. I see that a lot where a survivor is just incredibly concerned that they're going to come forward, no one will believe them, and then the trauma is just compounded even more so. And that's certainly, it's difficult and completely understandable. Or I'll lose friends. A lot of times, especially with sexual violence, the survivor and the perpetrator are in the same friend group, or maybe they're in the same neighborhood, or live close by, and they know it's going to be talked about, they know it's going to be a big drama, so it just inhibits coming forward. But the survivor does know that if I don't report or cooperate, it won't be that bad next time, I know what to do to avoid next time, I'll just, delete them from social media, I'll never talk to that person again, and I can just return to normal. No one will know, I won't have to go through any more hardship. Now, unfortunately, what we are seeing is that, there's still a traumatic event, and that usually still affects the survivor virtually every day, and it becomes incredibly difficult to live with. So those are some of the challenges that we deal with upon prosecution. There's a lot of challenges, as you see. So I do everything in my power to make the survivor feel as comfortable as possible in the process. But I always tell people, no matter what I do, no matter what I say, it is going to be an uncomfortable process. Now at the end, hopefully we're holding someone accountable, we're making sure this doesn't happen again, we're giving you an opportunity to face the perpetrator, so hopefully more good than bad comes out of it. But it is admittedly a very they've already been through something traumatic, and then going through the court system can be just as traumatic, if not worse. And that's very, very tough. So luckily, I try to attend as many trainings as possible. We're working with law enforcement. We have victim advocates in our office. So if there is a case that's sent to our office, even if it isn't charged, that person still has an advocate that they can talk to, that they can confide in. We have support groups, and we can also direct them to certain resources as needed. So path of a case upon charging. So if I get a case, I've determined that there's probable cause, the judge has determined that there's probable cause, and the case is filed. What usually happens is that the perpetrator is either summoned into court, depending on the type of crime, or a warrant is issued for their arrest. And once they either show up to court or they get arrested, that starts the clock on this kind of case. So what happens is first is that they have what's called an initial hearing. They'll go to a judge, and the judge will read the charges to them, and then they'll either hire an attorney, or if they can't afford an attorney, one is provided for them. That's called a public defender. And then what happens there is the case just moves. There's some more court dates. The defense attorney and the prosecutor, that being myself in these types of cases, we start to negotiate. We try to see, can we come up with an agreed resolution? Is there something that we can agree to that both sides think is fair and appropriate? Which happens, but I have noticed in cases involving sexual violence that isn't as common, because it's very hard for someone to admit that they committed something, very heinous crime. So a lot of those cases go to trial. What happens if the case goes to trial is that a deputy prosecutor will represent the state of Indiana, the defense attorney will typically represent the defendant, and both sides put out their evidence to either a judge or a jury. So what happens first is just we prepare for trial. So if I know a case is going to trial, I am talking to witnesses, I'm making sure I have all of my evidence, I'll speak to the survivor. I don't think either side wants any surprises during a trial. Now that does happen, especially if one of the sides isn't prepared. Maybe a surprise does come out, we just have to pivot. Or perhaps, again, like I said, a survivor change their story, or they might leave some details out, or add something in that becomes incredibly consequential during the trial. But usually, if you're prepared, if you talk to everyone, you can minimize the effect of those particular surprises. So in a jury trial, what we do is we have jury selection first, and that's when we bring in just a bunch of people from the county. We pick them from voter rolls and PIB registration and tax records. So you bring in a lot of people, and the defense attorney gets to ask questions, the state asks questions just about their attitudes and beliefs about these particular crimes and the laws, and we have a certain amount of strikes, how it works. And so I'll talk to a group of people, the defense attorney will talk to that group of people, and we'll go back and we can either strike for cause, which we have limited strikes for, and that's if someone is prejudiced or can't be fair or impartial, or we might have someone who is also a fellow survivor of sexual violence who says, I cannot be fair on this particular case, it's too close to home. So those people are just kind of excluded. I don't want to say automatically, but that's in effect how it works. And then each side usually has about 10 strikes. So there might be someone who I can tell, just give me like a very specific reason why I wouldn't want them as a juror on the particular case, but I have a feeling that they may not be fair to both sides. So we have 10 strikes there. So once we get a jury, once we get people who are going to listen to the case, we have opening statements. So each side gives kind of a preview of what they're about to see throughout the trial. And then we have evidence. So this is something I have to explain to survivors. We have something called direct examination and something called cross-examination. So if I call a witness to the stand, I ask them open-ended questions. So I have to ask them who, what, when, where, why. When the defense attorney gets to talk to one of my witnesses, they ask closed-ended questions or leading questions. So a lot of, well, you guys have been dating for 2 years, right? Or isn't it true that you don't remember much from this night? And so that's something that just is taught for the beginning of law school up until the end. So sometimes I take that for granted, but I do remember there was one survivor who testified and then was really confused because I was asking very open-ended questions, very narrative-based questions, and then she felt like she was being attacked by the defense attorney, which he was just asking leading questions. And she said, well, how is that fair? That for you, I have to, answer a very specific way, but for him, he's just asking me yes or no questions. So that's something that we work to prepare these survivors for, because testifying can already be very stressful, and we certainly don't want a survivor testifying to be surprised by something like court procedure. So after the state presents all of their evidence, the defense attorney presents all of his evidence, if there's any, the burden of proof is on the state. So in theory, the defendant could just kind of sit back and play cards. They don't have to present any evidence, and so that's just kind of the benefit they get, because they are the accused of a crime. And then we do our closing arguments, which is when we talk about all of the evidence, and we get to be very persuasive, and we try to just argue our case and say, this is why you need to believe this survivor. They have no reason to lie, or look at this medical evidence, or look at these messages between the two. We just go over and over what our evidence is in the case, and then the jury deliberates, and they come back with guilty or not guilty. That is at least a trial in a nutshell. So resources, if you or someone you know has been a victim or sort of has survived some kind of sexual violence, we do have victims assistance in the St. Joseph County Prosecutor's Office, Special Victims Unit, and I put their number up there. Elkhart County also has a victims assistance unit, but since we are in St. Joseph County today, I figured I'd put up their number instead. So we also have the SOS of the Family Justice Center, which is a 24-hour crisis line, and the National Sexual Assault Hotline. So those are all certainly resources you can use. Please don't hesitate to reach out to me. I love what I do as a career. I can't believe that I get to go to work every day and meet some just truly incredible people. My job is incredibly challenging, but that's why I like it. And I like being able to fight this fight. I truly, truly think it's something special that I get to meet people and then fight for them and fight for their cases. And again, work with a lot of people who are on the same team who are trying to get justice for this crime, because it's a really horrible crime, and it's horrible that people have to live with that. So I try to do what I can to help at the end of the day. Are there any questions? Yes.
When a case comes to your desk for you to analyze the charge, what's the timeline on that?
Sure. So the question was, okay, let's say I get the file, how long is it between when I get the file and when I charge the case? And it really just depends. So I had a case once that I had to turn around and charge it as quickly as I could, because the person was incredibly violent, and I was very worried about the risk that he posed to the survivor. The only reason police didn't arrest him that night was because they couldn't find him. So I knew that I needed to charge it, get a warrant out, so we could have kind of all hands on deck looking for this guy. So I tried to charge it within days of it hitting my desk. Other case, that's pretty rare. Usually what happens is it could be months to a year, because we do handle hundreds of cases, so there's a bit of a backlog. But most importantly is I get the case, and I read through it, and I want to be as thorough as possible, and I want to make sure I miss nothing. And then what I typically do is I go back to the detective and the law enforcement agency that investigated it, and I say, okay, so here's what I see. Have we thought about talking to this person? Or have we thought about getting these medical records? Or have we thought about getting the messages? Or this survivor said she talked to so-and-so right after the incident. What does so-and-so have to say about it? So then there's a lot of back and forth between that. And so we'll try to figure out, do we have all of the information we can possibly have? And so a lot of that then maybe law enforcement will give me a new case report, and I go, oh my gosh, this just opened up some more doors that we need to explore. So it really is a case-by-case basis, but it can be up to a couple of months, to even maybe longer, I've seen a year. We're just waiting on records or waiting to find a person, which is incredibly frustrating and so difficult for the survivor too, because as I said, they're typically still in the community with their perpetrator, and that I can't imagine how difficult that is. Or, even though a day goes by for me and I'm just working on the case, the survivor doesn't know that I'm still working on it, so they probably feel a bit neglected. So that's something I know that I've worked on, is just trying to keep the lines of communication open to say, hey, here's where we are in your case, we're working on it, and here's kind of the expected timeline. So the answer to your question is it just depends on the case, but I try to get them done as quickly as possible, but at the same time, I don't want anything to pop out of the woodworks while the case is pending. Yes? Sure.
One of them was when you were mentioning
Yes, the Gillier House.
so I'm from Illinois, over there, I know clients where roommates are considered part of these situations. So
Yes.
you're just, if we get an order of protection,
So yes, so domestic violence does not apply to roommates. Typically, they're looking for more like a domination, manipulation, control kind of relationship. So there are still remedies available. So if two roommates get into a fight, we can still charge that. If there isn't like a restraining order or a protective order, they still can be charged. It just doesn't meet that domestic violence. So it doesn't have that particular name attached to it. Does that make sense? Okay.
And the other question was, because I know you mentioned about consent issues.
Yes.
I noticed like it should call an organization called the consent clinic for any cases of sexual assault where like let's say they did have consensual sex before and then, you know, in a situation where there's no consent, like, is there anything similar to that here? Or, like they will help with cases like that to try to figure out if they can try.
Yes, so I guess we don't have something as official as a consent clinic, but it's something that we just have our law enforcement look into. So just because there was a consensual sexual encounter in the past, obviously does not mean there's permanent consent. Or, you know, we've charged cases where a sex worker has been sexually assaulted, so that doesn't mean that it's not a crime. But we do work with law enforcement, medical personnel, and prosecutors to make sure, here's what we're looking for, here's the evidence that we're examining, and at the end of the day, it's just, again, it's a case-by-case basis. So when there is consent, that is certainly an issue, but what I always try to bring up is, why on earth would this person make up lack of consent? Because they've been put through the ringer, they probably had to go through a medical examination, and now they're in court, they have to be in the same room as this guy, and a judge, and lawyers, and a jury. There's just no gain at the end of the day. So the issues that come up when maybe I can't charge the case is where I can start to see, like, maybe there's a very, very contentious divorce proceeding, or there have been false accusations in the past. That's an example of a case I might not charge, but it just depends. It really, really does on each case. So we don't have something as official as a clinic, but we do have law enforcement trained to look for those signs. Yes.
So I know that protective orders are like filed and issued differently and stuff. Does that automatically open a case for you, or how does that information get transferred?
Yes, so if someone applies for a protective order, that does not automatically open a case. There are two types of, I call them restraining orders just because I think that's the term most people understand. So protective order is its very own separate court proceeding. That's something that, you know, has to meet certain criteria and they get a protective order. In my cases, I have what's called a no contact order, which is a little bit different, but what it is it's attached to the criminal case, and so pretty much while this case is pending, defendant, you cannot have contact with the victim or be around them or anything like that. So that just lives throughout the lifespan of my criminal case. Whereas a protective order is very different, and it is separate, and it doesn't automatically open or bring anything to law enforcement, for better or worse. Yes.
What type of felony is a rape, and what are the consequences if one is found guilty?
Okay, so rape by itself, without any enhancement, is a level 3 felony, and so that carries anywhere from 3 to 16 years. So the advisory is 9 years in prison, or a sentence ultimately, 9 years. And so you start off at 9, and then if someone is guilty of that offense, whether they're found guilty by a jury or they plead guilty, then we have what's called mitigators and aggravators. So mitigators are reasons why it should be less than 9 years, and aggravators are reasons it should be more than 9 years, but it caps out at 16, and it's the lowest you can go is 3 years. If there's an enhancing circumstance, like a deadly weapon or deadly force or serious bodily injury, it's a level 1 felony. So that goes from 20 to 40 years, and it starts at 30. Yes?
What are examples of some mitigators in a sexual assault case?
So mitigators would be like age of the defendant, criminal history, if they have no criminal history whatsoever. There's statutory mitigators, and then there's that are like the judge has to consider, and there are other things like prison would be an undue hardship on their family. Aggravators would be that, you know, the effect on the survivor is more than what we needed to charge. Whether there's uncharged, there's a whole lot. So pretty much at the end, we can just argue one way or another, and the judge makes the determination at the very end. Any other questions? Yes.
Are there any cases that are on the prosecutor desk that are?
Against men, yes. And so I usually give this disclaimer at the very beginning. Obviously, this is a crime that affects everyone, gender, race, economic status. It affects everyone. It disproportionately affects women. So that's why I tend to kind of resort to the she when I'm speaking about the survivor, but we certainly have cases where men are victimized. They just don't seem to be as prevalent, and that could be for a host of reasons. It could be just kind of societal expectations. You know, men aren't really meant to be seen as victims of sexual violence. They might feel more hesitant to come forward. I don't know the research. I don't know that it has been researched extensively, but I know basically what I can see is that this is a crime that extremely disproportionately affects women. You all have been wonderful. I'm still going to be hanging out here a little bit more, so if anyone wants to come and talk to me or ask me any questions, I'm here. And I really, really appreciate your attention. Thank you for having me on such a beautiful day, and I appreciate the attention. Thank you very much.